So you've been wrongfully accused of domestic violence in Massachusetts. My name is Ernie Stone. I'm a criminal defense lawyer, and I've been defending cases like this for over 30 years. In this video, I'm going to answer the 4 questions that I'm most often asked about when I'm defending domestic violence cases. Make sure you stick around to the end of the video, and I'll tell you the 3 things you need to do in the next 24 hours if you've been charged with domestic violence. These are the 4 most common questions I get asked in these kind of cases. 1, can these charges be dropped? 2, will I go to jail? 3, what about the no contact order? And 4, can I beat this at trial? Let's talk about question 1, can these charges be dropped? The short answer is probably not, at least not at the beginning of the case. A lot of people think that if the accuser doesn't want to press charges, the case will automatically be dismissed. And unfortunately, that's not true. It's not up to the alleged victim whether the case goes forward or not. That's the prosecutor's call. And generally speaking, in Massachusetts, the prosecutor will almost always pursue these cases. But there is good news. If the alleged victim doesn't want to cooperate with the government and they don't want to testify against you, then the prosecutor won't be able, in almost all cases, to prove you guilty. If they're not willing to testify on the date of trial, in almost every case, the prosecutor will have to dismiss the charges. You just have to get to a trial date for that to happen. Now for question 2, will I go to jail? Domestic assault charges in Massachusetts do carry the possibility of a jail sentence. But for most people charged for the first time, even if they're found guilty, they're probably not going to be sentenced to jail. What factors into that determination? The severity of the allegations, if there are any serious injuries involved, if you have a prior criminal record, and if you've violated any court orders while the case has been pending. More on that later. What most often happens in first-time domestic violence cases is you'll be sentenced to probation. There will be conditions you'll have to satisfy while on probation. The first one and the main one is you'll have to do a counseling program, and it's a long one. It's once a week for 41 weeks. You may also have to do anger management. You may have to have drug and alcohol testing. The conditions depend on the facts of your case, but as long as you comply with the conditions, you won't have to go to jail. Now, question 3 is what about that no contact order? In almost every domestic violence case, a judge will order you to stay away from and have no contact with the accuser. That means no calls, no texts, no messages of any kind. And you have to stay a specific distance away from the person, their home, and where they work. This order includes having another person contact them for you. You cannot do that. A violation of the order means you'll be almost immediately arrested, and you might wind up being held in jail for the rest of the case. This can be the hardest part for a lot of people. If you live with the person who made the allegations, you can't go back home while the case is going on. If you have kids together, you'll have to work out visitation without having contact with the accuser. And if there's a separate domestic violence restraining order in place, in Massachusetts that's called a 209A order, a violation of that is a new criminal offense, and you're almost always going to get held in jail for that offense. And it makes the original case harder. On to question 4, can I beat this at trial? The answer depends on the specific facts of your case. But these cases are often winnable. Here's what matters. Is the person who accused you believable to the jury? Does their story make sense? And can it be shown that they've lied or exaggerated? Are they claiming that they were injured, even slightly? And if so, are there pictures and medical records that will prove those injuries? Is there video of the event? Or are there other people who saw or heard what happened? What the accuser has said before trial, whether it's on police body camera, 911 calls, social media posts, or statements to other people, can sometimes be used to show that they're not telling the truth. Sometimes you yourself might testify and tell your version of what happened, especially if this is a self-defense situation. So the bottom line is, sometimes the victim's story doesn't hold up, and sometimes the prosecutor just can't prove guilt beyond a reasonable doubt. Okay, so those are the 4 questions I get most often in these cases. Now, the 3 most important things to do in the next 24 hours if you've been accused. Number 1, get a lawyer. This is not do-it-yourself territory. You need to find a good lawyer that you can effectively communicate with. Number 2, you absolutely have to obey the no contact order. The biggest mistake I see people make, and this happens often, is they think to themselves, if I could just talk to the person, we could fix this. That almost always results in a new arrest, a new criminal charge, and their case gets worse. And number 3, preserve everything. What do I mean by that? Don't delete texts. Don't delete voice messages. Now, don't post on social media yourself, but don't delete your accounts. Save everything, because you never know if there's a statement or a picture or a post that proves an important fact in your defense. You're going to need to share all of this with your lawyer. In conclusion, domestic charges are really hard to face. There's a lot of emotion involved. People feel anger, shame, and fear, and they have a lot to lose. But don't lose hope. Even if your case can't be won at trial, a good lawyer can get you through with the best outcome possible. This is not the end of your story. You'll make it through this storm.